Let's have everybody, so welcome for the recorded audience that may see this. This is the ComplianceNet 2021 panel on compliance arguments for various models. We have people with diverse, very interesting, deep experiences who are going to talk to us about some of the work they're doing, some of the things they're thinking about as they're on the front lines of theorizing about compliance, implementing compliance, talking to people and consulting and on the rest of it. So we have a really exciting panel and I am going to let them introduce themselves. Let's see. Let me there's usually you would go down a row in a table. And what I will do is just take the order that's in the email that we've been sending around. So Robert, would you please introduce yourself and let us know a little bit about yourself and your work?
Sure. I'll assume Robert means me since there are
Yes.
two of us with that fine name. I'm Robert Bird. I'm a professor of business law and the Eversource Energy Chair in Business Ethics at the University of Connecticut. I've been there since 2004. I'm also currently president of the Academy of Legal Studies in Business, our professional academic organization in business law. And I have a focus in business ethics and, of course, compliance, and am co-director of a certificate in corporate and regulatory compliance at UConn. It's an online program. You complete 4 courses and receive a certificate, taking courses in both business and the law school. So that's my background.
All right. Jonathan, would you tell us something about yourself and your work?
Sure. I'm Jonathan Lipson. I'm the Harold Cohn Professor of Law at Temple University in Philadelphia. I am, among other things, the faculty advisor to Temple Center for Ethics and Compliance. It's a center that's been around for about 6 or 7 years. And the center does a variety of things related to compliance. We have hosted academic programs. We've hosted a large number of professional education programs for compliance professionals, both legal and non-legal. We produce a fair amount of content on compliance. My own background actually does not involve a great deal of work in compliance, at least it hasn't historically. Most of my work has involved what you might think of as more general business law. So I teach contracts, I teach corporations, I teach commercial law, the stuff that the students consider scary and boring. But when you help them understand that, in fact, it's relevant to things like compliance, like some of the things we'll be talking about today, they get a little bit more excited.
The other business law professors would argue it's the stuff that makes the world go round.
Totally true, totally true. But you do have to manage expectations.
Oh, man. All right, Rob, please introduce yourself and tell us a little bit about your background and work.
Sure. After being a prosecutor for 10 years for Robert Morgenthau in the DA's office in Manhattan, where I was mostly a mafia prosecutor, I went to Goldman Sachs, where I spent 27 years in compliance. For most of the time, I was the head of all of our sales and trading compliance globally. And then for 4 years, from 2013 to 2017, I lived in London, where I ran all of our international compliance efforts across all of our businesses. I retired from Goldman in 2020. And since then, I've involved in a number of things. Currently, I am in a PhD program in philosophy at the New School for Social Research here in New York. And I'll be writing my PhD dissertation on business ethics. I'm also an advisor of the New York State Attorney General's office, where I'm advising them on securities and consumer fraud. And I'm actually also an integrity monitor, part of an integrity monitoring company that does monitorships for various companies that run into trouble. So I would say my entire career has been focused on compliance and ethics.
Very important. And Rob's got amazing stories and insights, really incredible. So let's start with some questions for the panel and let's see what kinds of different answers they have. So obviously, if we are talking about compliance and arguments for various models of compliance, let's ask, what is compliance? This might be a different answer for different people. Let's see. Do you want to start again first, Robert?
Sure. Well, that's a question that any of us could answer, and we could fill an hour and 45 minutes just discussing what compliance is, right? But you need to boil it down to a few things. And the word compliance, in its modern disciplinary sense as we use it now, right, it hasn't reached the point where everyone has the same definition, right? It varies. But compliance, I see compliance as not only the act of complying or conforming to a given set of standards, whether formal legal standards or informal norm standards that are established by a company. It is the sustaining of those standards over time. So there's a temporal element to compliance that exists, in addition to actually going from non-compliance to compliance, but complying over a period of time. And then I think finally we talk about compliance as from the perspective of maybe a sociological or psychological research, where they look at nudges and you look at efforts to make people do what you want them to do through subtle efforts and other behaviors and structuring and framing ideas. So I think that's the different ways. There's the act of conforming, the sustaining of conforming, and then there's the scholarly discipline of, which thinks about conformance of it. And under those three banners, you have a wide variety of influence. So that's how I define it, at least for my students. And I think it's a great starting point for a panel such as this.
Well, let me actually follow up on something that you talked about in our phone conversation before the panel started. And you were talking about whether compliance is really a one size fits all or really has varied cultural settings. Does it change the definition of compliance by cultural settings too?
I think as more we understand how culture and compliance interact with one another, I think we get a more robust definition of what compliance is. And one size fits all obviously can't work. And each company, although the laws may be the same in a given jurisdiction, each company has its own legal mix of liabilities and risks and cultural issues and things that they're responsible for. And so a good compliance professional has to know what the company's culture is, has to know what that unique legal mix and risk is for that firm, and then make decisions with that environment. So through the process and the sustaining of compliance, you need to know so much about the contextual factors of the organization and its employees and the legal environment. And I think that's often done. That may not be always best done, but in-house counsel, a dedicated compliance department, chief compliance officer, et cetera, whose focus is on this task primarily. I mean, compliance really is one of the keepers of the culture. If a compliance department can really convey why compliance is important, they can build a long-lasting culture of integrity, which we may talk about later, which is something that's valuable for an organization to have.
Let me turn to Rob next, actually asking him about his definition of compliance, but then also he has had the experience of running a compliance department, obviously in the United States, but then out of London for around the world, and what he learned from that experience about what compliance might mean in different contexts.
I actually like Robert's definition. It's pretty comprehensive. And I just, from a pure definitional standpoint, I have nothing to quibble with on that. What I would like to talk about, though, in response to your question, Josephine, is the relationship between compliance and ethics. Because all too often, I think there's simply too much focus on legal compliance with laws and regulations, and that can distort an actual compliance process. So I have a few points I just wanted to make about that. I think it's essential actually to have a focus on ethics in order to have a good compliance program, and here are the reasons. Obviously, ethical principles are often coincident with and even stricter than legal standards. And since anyone who's grown up in a society has a built-in ethical framework, which has allowed them to basically live in an ethical way, and they know what ethics and what unethical behavior is, and they have years and years of experience with that. Whereas when they enter a company, they have a very strict, restricted number of years of experience with whatever the rules are that are relevant to that business. If you can get an environment in which you can encourage people to use their ethical frameworks that they brought with them to work, you're 3/4 of the way there to legal compliance. Not 100%, but 3/4 of the way there. And I say not 100% because there are plenty of rules that are counterintuitive, or as in my own industry, finance. They are the rule sets are too long. You can't rely on employees to actually know them all. If you try to do that, you're going to fail. They're going to fail. You need to get them to focus on to activate their ethical frameworks in order for them to comply with anything. So that's the first point I wanted to make. Second point, I have 5 points, brief points on this. Second is that many legal rules essentially are ethical rules dressed up as a law. I mean, in finance, which is my experience, there are laws that require you to engage in fair dealing or to comply with fair and equitable principles of trade, whatever those are. Those are simply an embodiment in statute or in rule of ethical principles. Third, bad facts make bad law. And when a company or an employee does something that's morally bad, plaintiffs' lawyers, regulators, prosecutors, they will stretch even precisely drafted laws to make the bad conduct illegal, and they'll throw the spaghetti up on the wall. In my experience, something will stick. Maybe I'll get a settlement. Nobody wants to defend, no corporation wants to defend really bad conduct in a court of law or in the public forum. Say, well, it's technically not illegal. So people take advantage of that. So in fact, these days, virtually any fraud, any bad thing done in a public company can be described on a fraud as on investors, right? You should have disclosed that you knew that there was sexual harassment going on. So therefore, I've got a fraud case against you. My last 2 points are very quick. Bad ethics, even if it doesn't result in a legal problem, is going to hurt your recruiting. You can't hire good people if people are in a company has a bad reputation. I remember during the financial crisis, 2008, 2009, Goldman Sachs was probably the most reviled company in the United States. I was ashamed to go to a party and say that I was from Goldman Sachs. So I know very personally how difficult it is to have a company that has a bad reputation. If you want to get good people, you need to do that. And the last thing I'm going to mention about ethics is that, of course, bad ethical practice create scandals. They lead to bad press that can drive customers away, and it attracts very unwanted legislative interest, which is never good for a company's business. So even if you're complying with all the laws, if you do things that are bad, that violate ethical precepts, you can end up ruining your business. So I think it's really important to have ethics embodied in your compliance program in some way. I should last one thing I'll add is I've forgotten to mention, so feel free to ask me about this. My last 3 years or 4 years at Goldman, 3 years, I guess, I was the senior ethics advisor for the firm, and I helped develop our ethics program, ethics committees. We brought in McKinsey, and we put in place a nudge program based on those principles. So that's it.
Lots to talk about. I want to ask you though, and this is great. Now I can ask you as a PhD student in philosophy and ethics as well. When you keep saying ethics, we're finding that there's less and less agreement across cultures and societies about what that is. And ironically, it does seem to be that there's more agreement on the little things like hospitality and, inviting guests into your home. That seems to be fairly universal, and far less agreement about the big things like murder. In some cultures, you can't murder at all. In others, you have to do honor killings, right? There's definitely a huge difference there about what it is that we have as social expectations for behavior. So when we start talking about ethics and, have people use their code of ethics, what does that mean in running an international company?
I will specifically answer that question rather than go to the broader issue, which is what is the nature of ethics and its cultural relativism, the good or is true or not. What it meant for us is that we chose what we considered to be the highest standard in a particular area across any of our companies and any of the jurisdictions in which we were in business, and we applied that to the local area. Now, part of that was done because we wanted to have the ability to send people from office to office so that they would feel comfortable. So we wanted a one firm ethic. Part of it was because we had a principal regulator. Early years, it was the SEC. Later years, it was the Fed. And they didn't want to hear that there was somebody doing something bad in India that they didn't like. And we would say, but it was legal in India, or that it met local practice. That being said, we had a process. Just, you want to know, get down to nuts and bolts, because I see Robert and Jonathan are both sort of practitioners in this area, at least from the academic perspective. We had a practice that if you felt that you wanted an exception. And in India was one of those places where their anti-money laundering rules, well, India had a number of problems. They were trying to go to force us to disclose overseas Indians who they thought might have been evading taxes. And so there were a number of things that the Indian regulators did that were below our standard of international conduct, that is, including things like privacy. They also were much looser on anti-money laundering laws. So what we did was we had a process where there was an exception process where the person in a local jurisdiction could make an appeal to the head of compliance globally to say, here's the exception, here's why. I would bring it to an internal committee to see if we were willing to accept the risk. And assuming that we thought that it was ethically, that we could defend it, that it was ethically appropriate. It may not have been perfect, but it was ethically appropriate. And that's how we did it.
Yeah. Yeah, that makes all kinds of sense. Well, Jonathan, I saw you nodding and making other faces at different points. So you obviously have a reaction to some of the things that Rob was saying. And so let's ask you about your definition of compliance. And I know you have some thoughts on whether it's only corporate governance, whether it's more, what it means.
Sure, thanks. Let me start, I guess, from Rob's observations, work back through Robert's, and then say a few things about definition. I think Rob's completely correct that compliance is not meaningful if you don't account for the ethical implications of compliance, or not the decision to comply or not, what it means. That checking the box by itself is a problematic culture or system or what have you. But in addition to there might be different cultural norms in different places question that you just asked, Josephine, there is of course always the problem that some people might actually need to have their ethical compasses adjusted, and that can be, I think, equally challenging. And whether culture is sufficient to do it, whether what sort of incentive structure you need to do that, I think is important. So our center at Temple is called the Center for Compliance and Ethics. So obviously, I agree that ethics is critical to all of this, but I think it's very difficult, and not only because we spent 3,000 or 4,000 years not understanding what the word ethics means exactly, but because it's especially hard in this context. For Robert Byrd's comment, I think you started by saying that any of us could spend an hour answering the question, what is compliance? And I have to say, like, I could spend an hour asking the question, but I cannot begin to know what the answer is at some level. In part because I think it's so new. So let me give you three definitions that are out there. As I think you all know, as those who are watching this would know, the American Law Institute has started fairly well into a project to articulate the principles of corporate compliance. I believe the reporters Jeff Miller, Jennifer Erlin, Jim Fanto, and Claire Hill are assistant reporters, and it's I think a really interesting and good project. Their definition, current definition, they're only in their second tentative draft number 2, defines compliance as follows: quote, adherence to applicable laws, regulations, rules, or an organization's code of ethics, its ethical standards, or legally applicable or otherwise binding industry codes of conduct, and appropriate cooperation with regulators. Now, what's interesting to me about that definition, it's quite broad. I don't think there's anything especially offensive in it, but it's mostly a process-driven definition, which is an entirely sensible thing for lawyers to do, to say, well, we're going to focus on processes that will lead to better outcomes, because that's what lawyers do. We're good at process. But of course, you could also say, well, maybe there should be different substantive outcomes, and you should think about the definition of compliance in a substantive way. If so, that might produce a sort of a different set of insights. Speaking of insights, a publication called Corporate Compliance Insight has their own definition. They say a corporate compliance program is generally defined as a formal program specifying an organization's policies, procedures, and actions within a process to help prevent and detect violations of law and regulations. Again, it's all about process, but it doesn't really specify a great deal about what the goal should be, or in substance, how one should attain the goals. I have a working definition that I am sure is highly incomplete and could bear a lot of development, but as I think about it, it's an organization's efforts, compliance is an organization's efforts to internalize external rules, regulations, norms, and standards that are material to the business and operations of the organization. And the key point for me, and maybe what distinguishes it from those other two, is that I think compliance is new and important because it's a way of articulating a major shift in the relationship between public and private. And so you can, I think all the academics, sort of imagine that the world could form a continuum of, the highly private to the highly public. And, for many years, I think we assumed that the government was government's job was to regulate, and compliance simply meant doing whatever the outside told you. I think beginning with the deregulatory moment in the Carter administration, we saw a transformation in that. And so increasingly those functions that were public functions to regulate or interdict problematic behavior were increasingly outsourced to the private sphere. And so compliance is a response to that. That's what compliance is. And, it doesn't tell you substantively what it should be, but it does tell you that there's something very important and I think really complicated about what's going on. It obviously involves process, that's what the lawyers like, but it must involve substance. So you started out by pointing out that, for many folks, corporate compliance looks like it's about corporate governance. When the ALI project began, it looks like that's how the ALI was approaching it. My sense is that they've expanded their horizons significantly and now absolutely take into account ethics. They absolutely take into account white collar crime. Those are certainly two drivers of it. But you could also say that from a disciplinary perspective, for lawyers at least, it also might include things like legal ethics, which of course are professional ethics, which are different from the kind of ethics that Rob was focusing on. It might include things like administrative or regulatory law, because those are the sources of many of the rules, not all, but many of the rules. My own personal sort of kind of niche in this is contract. The contract becomes a mechanism to drive compliance through, for example, a supply chain. And then you can sort of get into all the various, actual substantive rules about compliance. So FCPA is a thing that we all have to, kind of think and worry about. And the GDPR, the HIPAA, whatever it is. And those are all elements of compliance. So to me, I guess the short answer to the question is, what is compliance? Is I don't really know yet. And I think that that's part of what makes compliance exciting and important, because I think it's reflective of larger sort of shifts in the economy and the distribution of power and the distribution of wealth, and sort of efforts to kind of manage that. But I think that means that we're just at the beginning of something. And so I certainly don't know really what the definition is, even though I think it's a really important exercise. And I would just finish off by saying that I completely agree with the versions that Robert and Rob offered. But I think that it's this is just the beginning. It's really not the end.
Rob, did you want to jump in?
Yeah, I wanted to make a point and then ask a question of Jonathan. The point was, I was there at the moment when the AML laws were created. And I remember talking to a regulator and saying, this looks to me like you're taking an obligation that was traditionally the government's obligation and basically saying, you now have to do it. And she said, absolutely. We've written the rules precisely to put it on you. And that was a surprise to me because, it seemed to me so clear. That was one thing. So I agree with that. There's other one's a question. This is a genuine question because it came up during the course of my career. I mean, Goldman's a very big and complex place, and anything could be called compliance. And under banking regulations, the core concept of a banking regulator is to ensure the safety and soundness of the institution. So compliance in that context can mean not doing what is necessary in order to avoid a claim against you that you're not safe and sound, which literally can cover every single thing the bank does. And in particular, I was thinking about contract compliance. There were times when I was asked, would you make sure that we're in compliance with all of our contracts? Because if we're not, we'll lose money. And if we lose money, we won't be safe and sound. As a practical matter, Goldman we chose not to do that and to focus on what we considered customer-facing, to us at the compliance department, focused only on a certain slice of everything the company does. And it was focused on customers and markets. That's in our business. We did not focus on the internal processes necessary to ensure the Fed didn't come after us on safety and soundness. Curious what your view is.
What my view is on
whether that's kind of compliance that you think belongs under the definition of compliance, for example, in the ALI.
The idea that safety and soundness regulation is a form of compliance, or that the decision to focus on customer facing matters rather than internal systems.
That corporate compliance involves compliance with all aspects of the business, which could conceivably result in a finding of lack of safety and soundness. That is, your credit monitoring, your risk monitoring, your contract monitoring.
Right. Your environmental monitoring. Yeah, no, it's right. That's part of the problem with compliance. Like, it could be everything. I think that's completely correct. So, in my little definition, like, materiality ends up being important because, lots of things are not material, and obviously there are many things that are internal to the business that don't seem to have much to do with compliance, even though I think it depends in part on what the business is. So as you were talking, you were using the word, I think, context, and sort of in the banking context, safety and soundness is the mantra. When I first started teaching, I taught banking. It's been many years, but my recollection is that it was an intensely law-driven business, and so part of what I think this is kind of a classic law professor's answer, which means it's not necessarily an answer, is that I think it probably does depend on what drives the context. So, for example, I think that one could say, well, for some businesses, law really does drive context, right? The banks failed in 1929, and Congress came in and said, guess what, guys, you're going to do business very differently, and we're going to tell you exactly how that's going to work. Many businesses are not, don't have nearly the same kind of interaction or history of interaction with an external force, and so for them, the context might be very different. But that begs the question: should law be the thing that sets the context at all? In banking, it sounds like it might be. In the case of many, businesses that don't have that history, maybe this is where, like, the internet is. There isn't really that history of interaction, and indeed a strong resistance to interaction between the public and the private. And so things like the business, or things like self-regulatory norms imposed, created or imposed by trade associations or clubs or what have you, maybe those are the things that determine the context that then helps you say, well, this is how we should think about compliance. And of course, there are always questions about culture, as you pointed out. So I think banking in some ways may be I don't want to say it's sui generis, but it may be an unusual example, both because it's got such an important interaction with the state in its classic form over 250 years, and the more recent regulatory history, starting with the National Bank Act. But nevertheless, I think I think what's embedded in your question is really important, which is like, almost everything could be compliance, right? Even for Facebook, which says, guess what, you were immune from your antitrust laws, so go away. Like, they, I'm sure, care about being seen to comply with at least their own terms of service, whatever those might actually say. And to them, that may be a form of compliance that matters. So bounding compliance, I think, ends up being a really important part of the exercise, including the definitional exercise.
Let me follow up on something that Rob mentioned, and then I'm going to pull Robert into this conversation by switching topics slightly, which is to think about our next sort of big bucket of things that we wanted to bring up, the role of regulators versus the role of firms in compliance. And Rob mentioned two things. Actually, he was picking up something that Jonathan said, so it gets the two panelists in there, and then I'm going to ask them to respond and then throw it to Robert. So first, earlier in your comments, Rob, you mentioned that your major regulator was the SEC, and then it was the Fed, and that you felt as though that regulator's interpretation of compliance became the de facto interpretation for the firm frankly, around the world, right? Because you were worried about what that regulator would do. And I was wondering if that's just who is most active, right? If some regulator became very active, would they emerge then as the top regulator? And is that an appropriate way of for regulators to act and therefore be pushing industries? And then second, you mentioned something, and you were picking up on Jonathan's point, but it was a question I wanted to ask, which is this: well, if you're going to be very active, then don't you also have responsibilities to set the rules and the expectations for the enforcement of those actions? So how can you go ahead and outsource all this private regulation to these firms, but then hold them accountable, and in fact, increasingly with personal liability for compliance officers in some regimes around the world? And now there's this discussion that Cindy would talk about ESG and potential liability for personal liability for compliance officers on ESG issues. How does that make sense in terms of, you know, where is the role of the regulator? Where's the private firm? Have we moved too far in different directions? And is there an abdication of responsibility, yet still an imposition of liability that seems unfair, given the abdication of responsibility on the articulation of how compliance is supposed to be actually lived and experienced and enforced?
Who's that question for?
You first, and then if you know, you know, Jonathan was part of that, but then I do want to get to Robert Byrd on this question of what the role of regulators is too. So it's for all of you, really, if it's sparking thoughts and discussion.
So which regulator was the most active was a political decision by the regulator for the time. After the financial crisis, the FCA in London was all over us for things in the United States, because they were very worried about, they had gotten political pressure, and this is something we can talk about more, the political pressure on regulators. So I don't think there's any strong logic as to which a regulator is going to want to take a bigger role versus a more backseat role. Second thing I wanted to say was I actually like joint government industry partnerships. I view us as all on the same side, certainly the big firms. And I think most of the big companies, certainly in their senior executive suites and in their senior compliance and legal staffs, I think take that view. And the question is how best to achieve a true partnership given the different interests and perspectives we come from. I by no means wanted to dispel my somewhat cynical comment about the regulator who told me that they were putting all these obligations on us was because I don't think that was done honestly and openly and out in the open. It was sort of, it was in the back rooms, and through small rule interpretations that were done slowly over time, we got that view. Let me just say one other thing, and I don't mean to dominate this, but I view it's really, really, really important for regulators and regulated to trust each other as much as they can. And I've seen the two different models. I've seen the United States model, and I've experienced it, and I experienced the UK model, with the FCA has a relationship which is so much better with its regulated firms, far less adversarial. And I think the reason is I went back and looked this up. Simple, Lon Fuller's classic, The Morality of the Law book. I just want to say them on the record for that. If you do these 8 things, your enforcement is perceived to be more ethical, more moral, you can be more trusted. The law has to be sufficiently general. It has to be publicly promulgated. It has to be prospective. It has to at least be minimally clear and intelligible, free of contradictions, relatively constant so that the law doesn't change continuously from day to day. And I would add from supervisor to supervisor. It has to be possible to obey, and it has to be administered in a way that wildly diverges from its obvious or apparent meaning. Those are his rules. Like, I don't remember, 1964, I wrote it down. In my experience, over my 27 years, many, many US financial services supervisory investigations and enforcement actions did not meet those standards, And as a result, we have an absolutely horribly strong adversarial relationship in the United States. And that I think hurts. The UK is much, much different. And I could tell you stories, but I won't, unless you ask me to.
Well, that's really helpful. I did want to pick up something that Jonathan had said he wanted to talk about in our pre-panel conversation: private ordering or public law, and is this a spectrum? And can you place us within that spectrum? Where are we? Are we moving from one direction to another direction? Is it appropriate that we move from one direction to the other direction?
So I would love to talk about it, speak to that rather. I did mention it briefly earlier, but I wanted to see if Robert Byrd had any reactions to what Rob had just said about the role of regulators, whether, for example, well, what I mean, there are a lot of things one could say about regulators and the kind of sausage that goes, into actually producing both regulation and those who either, promulgate it or those who enforce it.
Sure. I mean, there's a lot. I mean, there's a lot to say. You both have covered much of it quite well. And you mentioned the analogy of the sausage. We just sometimes want to know how the sausage is made. The law is made, backroom deals, last-minute arrangements, and deflection of controversial issues that matter very most to the regulated. So when we get vague rules, when we get imprecise regulations that are confounding to firms, it may be the product of negotiation that says, we will not answer these tough problems. We're going to let businesses deal with it, and then we'll interpret it later. And that places that responsibility firmly on the enterprise, which is confounding for the compliance professional and frustrating to whoever the compliance professional reports to, because one of the least satisfying answers we can give our internal clients is, it depends, which is the famous phrase that lawyers have been using since, I'm sure, the dawn of practice. So we do have boundaries, right, in the law, but these really, they're not really sources of effective boundaries, right? We have laws can be rendered unconstitutional for vagueness and overbreadth, but that doesn't really apply in a situation of compliance. So the question, what I see compliance is, there's going to be a pendulum that goes back and forth. It begins with first command and control. We are the regulators, you shall do this, right? And we have to follow what that is. And it becomes a frustrating cat and mouse game between a regulator and a firm. Then there are ways of new governance, collaborative regulation, regulatory design that will place the impetus too much on the firm and say, okay, this is something you need to do. Here are your standards. Here's what you say in the United States Sentencing Guidelines. Go to it. Then we find that that's too vague and it's unwieldy, and firms will be, well-meaning firms will not be able to accomplish. And then we'll go back. They'll have a response from legislators and regulators defining things more precisely. So there's a whole evolving literature and discussion on how regulation works and how it is designed and how is it implemented effectively. And I think the European Union and European scholars are ahead of us Americans on this scholarly bent. There's a lot of work that's been done on good governance and regulatory design within the structure of a very bureaucratized environment of the European Union. So I think of it as like a pendulum. It swings back and forth, but as it does, it gets better and better. And as each swing occurs, the more we get closer and closer to the optimal environment. But with compliance, we're really in the nascent stages. We're just at the beginning of what compliance is. And if 4 bright people in a room can't answer a question about what is compliance is in under 30 seconds, right? That means we have work to cover. And I think that interaction is really critical, right? Regulators want to have someone they work with that's in good faith, that they can work with in good faith. Firms want to comply with rules. And if you have someone like Rob at the helm, right, you want to work with regulators. Not every attorney necessarily does or has that good faith intention. So it's that collaboration that's going to provide that most effective value. And once you have that collaboration, you generate trust. And trust is a valuable asset in any arrangement, because what that trust does is it reduces the need for checking and enforcement and evasion. And it actually reduces the transaction costs of the arrangement. And now what you have is what I call a trust surplus. And when you have that trust surplus, now it's resources that can be dedicated elsewhere. Regulators can not spend time worrying about firms that are complying in good faith, focus their limited resources elsewhere to catch other bad guys. Firms don't have to spend as much time in compliance in terms of reaction and defense, but can spend those resources allocating towards new areas about building a culture of integrity, building sound ethical practices, building a culture that provides that compliance is so important that it's something that everyone embodies, and the norm is transmitted amongst employees, not just from the top down. And if we can get there, we can make our organizations a lot more effective. and keep our organizations, out of the negative spotlight.
Is it that trust that's underpinning some of the points you said you wanted to make in our phone call before the panel about perception and management of legal rules? Or is that a slightly different point? Do you want to launch into that?
Yeah, I can
I
tie it in.
actually,
Go ahead.
I was going to just pick up on something that Robert said, because I think his observation is really important, although maybe controversial. I mean, on the one hand, I think it's absolutely correct that in, sort of 85% of cases, we probably do want the kind of culture of trust that Rob has described, and that, sort of a different theory or approach to regulation might produce. But, like, remember, right, like Tulloch Stigler, said, like, regulatory capture is the thing that really matters. And firms, the bigger firms, want regulation of a certain sort so that they can squeeze out the small fry. And, when you go, I mean, I don't know if you're familiar with Wendy Wagner's work, but like, she's looked at, sort of the rulemaking process. And in many cases, and Rob can, correct me on this, or correct her on this, I guess, it's really the regulated, the most sophisticated, well-resourced of the regulated that write the regulations. I don't think cynically, I think they do it because they're the most sophisticated when it comes to many many sets of regulations, especially financial services or anything very technical. Government has to rely on them, but that has a bunch of other implications. I think it does produce a kind of trust, and I worry about the kind of trust that, for example, you saw as being problematic in Lehman Brothers, or that some say, was problematic in Purdue Pharma before its bankruptcy, right? Because in both cases, you had very close relationships between the regulator and the regulated, and things didn't work out so well, right? The result of the compliance failure was bankruptcy. And so, Lehman Brothers had regulators sitting in the building in, 2 doors down from the folks who were doing the repo 105 transactions that, the regulator said, oh gosh, that's terrible. How could you do that? And I don't think it was because, I mean, who knows kind of what the intentions were, but I think figuring out the right balance of trust and mistrust to me is the important thing. How much tension and how much, slack do we want? Part of it, when I was thinking about this today's program, part of me thought, like, the prize is going to go to the person who can write the Priest-Klein article about, enforcement, right? So everybody knows Priest-Klein says, when do, private order, disputes like contract disputes or tort disputes, when do they go to trial? Well, very rarely when there are sort of significant information failures, whatever. But I don't know that there really is a Priest-Klein version of that analysis for enforcement decisions, because if you could do that, then you might answer a whole bunch of other interstitial questions about, like, how much trust do we want and how much mistrust do we want? Because I think too much of either is a problem, but figuring out what the right, sort of happy medium is, I think that's hard. So anyway, I'm sorry to interrupt, but I just wanted to react to that because I thought those were really important observations.
That's excellent. Yeah, I agree.
On regulatory capture, which is obviously extremely important, I'm curious whether you have any practical suggestions, being the practical guy here, practice guy here, of how best that can be done. I mean, for example, I've given you an example of something that I thought leads to lack of trust, which is the violation of those rules of morality of the law. But, when those people come and sit at Goldman or at JP Morgan, and we have 30 or 40 of them, if they don't talk to us, they're not going to find out what's going on. If they do talk to us, they may be misled. They don't have, we have 35,000 employees. They have, maximum all across the world, 50 that could possibly be looking at us. They can't what's your suggestion for how it can be done?
Are you asking me?
Either of you or Josephine.
I'm not the guy from practice. I haven't practiced. I have a pro bono client in a matter today, but I haven't practiced law since 1999. So I'm not sure I have a good practical answer. I have some sort of theoretical answers. But Robert, you want to take or Josephine, either of you want to take a run at it first?
Yeah, we haven't heard from Josephine. That's true. I mean, sure, she's a moderator, but also as astute as any of us in these subjects. I'll give it a shot, and you can give you a chance to think about it. So, right, you're getting into the classic question of enforcement, right? Enforcement only works if a very high percentage of those to be enforced agree with the standards of enforcement, and do so in a way that doesn't require enforcement punishment in order to compel them, right? And so if there are so few regulators, how do you regulate such a massive amount? I think the best thing that regulators can do in that situation is that they need to do signaling effects, which is that you take a prominent positive or negative situation, either a trust relationship, and you broadcast how useful it is, or a negative relationship and say, hey, this is how we punish this person. And you're looking for relationships that create what are called the deterrent effect. And I think what can incorporate or try to solve this pressing problem, and I don't think there's any easy answer for it, is to look at deterrence theory in criminal law. Deterrence theory says that there's three factors that deter people from committing crimes or bad acts. It's the response from the state. When the response from the state is swift, when the response from the state is certain, and when it is severe or proportionally severe. If you have all those three things, deterrence is most powerful. And so what states need to do is to use their limited resources in order to maximize the deterrent effect. So one effect changes the behavior of 50 or 100 or 200. This isn't easy. It takes time, it takes cost, and you can make mistakes. But enforcement of compliance intra-organization and outside the organization compel voluntary agreement by the majority of the governed. Otherwise, you simply have chaos.
Sure. And I would say this comes back to something that Rob actually wanted to talk about in the phone call before the panel, which is this need for regulatory fairness and perception of fairness. Because you need people to buy in, and you need people to want to do these things. There is no way as a cop on a beat that you can, hold back a crowd if they decide that they want to, storm the stores and do all the rest of it. What you have to do is you have to find the people who are going to say, hey, this is not who we are. This is not what we should be doing. And turn the tide that way. And that's hard. That's really hard, especially when I feel like so many of the norms of our institutions are under attack. And there are fewer people willing to stand up and say, hey, this is right, and we should do it because it's right. That's a more and more tenuous position to be taking sometimes within organizations. And I think that this is maybe a pendulum swing of what we're going through right now after watching some really dramatic behavior over the last 4 years that didn't necessarily have repercussions. And so people started to question whether they really did have to behave properly. And we actually saw, interestingly, I mean, this tone from the top works as a whole society. We saw aggression toward women increase over the last 4 years dramatically. We saw aggression toward minorities increase in the workplace dramatically. We saw language being used that would have been checked before, either because somebody else in the room would have said something and said, that's not really a joke we should be telling here. Or the person themselves would have self-censored that language because they knew what kind of response they would get telling that joke in the workplace. So there's something about steering this very large ship where lots of pieces have to be in place, and you have to make sure that there are many people, many hands on the oars, right? It can't just be those couple of people marching in and saying, okay, we're the enforcers, turn over your books and we'll find everything. You actually need some buy-in on the part of the organization that's being regulated to say, okay, we understand why you're asking these questions. We agree that these things should not happen. This is your point about, is it ethical? Is it unethical? And what's unethical today will be tomorrow's regulatory system, right? And prohibited under that. But you need that reaction from people. And I think that what you get otherwise, if the law, and part of this is maybe, especially in finance. So let's take two different industries with very different experiences, finance and say food safety, right? In finance, you get sometimes really technical laws that people don't understand, and they don't know why I have to do that. And maybe the reason is there that some regulator needs the form in that particular set of calculations because they're comparing it with something else, but they haven't explained it, or there's a checkoff box, or there's something that's very technical and so doesn't resonate with the ethical reason behind it, or the ethical reason is not as apparent in why that regulation is there. And then you have in the food safety context, a very compelling, oh my goodness, if I don't follow basic food safety standards, we could kill people, right? And so you tend to see not only are the rules kind of a little bit more streamlined around, public health and safety and, please don't kill people with your food production techniques, but you also see more obvious buy-in sometimes on the part of people on the plant floors where John Braithwaite was telling a story. Coal mines, there's a really good example. Mine safety is the difference between that roof staying up above the heads of the coal miners when they're down deep under the ground and the whole mine collapsing and or flooding and or fire or something terrible happening, right? It's immediate. It has the stakes of immediate life and death. And so it is in that context when John Braithwaite goes down into the mine with someone from the company who's a local inspector and in charge of safety, that inspector tells John Braithwaite, by the way, I have already reported this to management, but should you, the inspector, walk, so many meters down this part of the mine shaft and take a look to your right or left, you will see something that will be of interest to you that I have reported to management. They won't do anything about, but maybe you can tell them to do something about, right? You get that buy-in. This is somebody who works in the mine, who has obviously been bothered by whatever that safety issue was and has tried to do something about it and is now appealing out to the regulator to please use their voice as well. So I think that's when regulation can be amplified. And so it's not the number of inspectors, although Braithwaite's point is we need actual physical inspections on the ground to do that. You can't do that and have those kinds of interactions through computer monitoring, right? And vague audits and the rest of it. You actually need to get into the mines, talk to people, have someone in some dark corner of a mine who will say, hey, you human being to human being, walk that direction a certain number of paces and take a look, right? That could happen on the factory floor. That could happen in many other contexts. But I think there's something to the fairness principle, to the humanity of regulation. This is very much Braithwaite's point and the literature around that. That's really important. And I think that, that's easier maybe to see in some industries than others. But it's got to be there in some form or people will rebel. And what we actually see is a surprising amount of sabotage sometimes with if the rules are not explained to people and they feel as though they are arbitrary, you can get sabotage. And it's because people bridle at just what feels like arbitrary control and invasiveness.
Can I just follow up, Josephine? I agree with so much of what you're saying, and you actually said something. You said some things that triggered some new thoughts for me. The sort of the basic level is that if you have this amazing engine, each employee has this amazing engine that can do great things, which is his or her ethical sense. If it feels bad, they don't want to do it. Virtually nobody is just a devil who. You're not going to build a system around the one or two devils. Most people don't want to do things that are unethical, and they're upset with them. And you're absolutely right. You've mentioned it, that the farther rules move away from what is ethical, the more difficult it is to get people to feel really invested in complying and reporting compliance. I will tell you a story, which is that we actually, it's part of our nudge program, realized that there were some violations on some trade reporting things that were going on in one particular desk. And when we went to interview people, it was very clear to us that they did not understand why this aspect of this thing had to be reported this way. They were kludging together something because they thought it was actually better. And once we explained it to them, the problem cleared up because they said, "Oh, I didn't realize that it was these reports, if they were false in the way that we were falsifying them, was going to mislead investors. It was just something they were putting into their system because they thought it worked." So absolutely, the point you make that explaining to people the ethical underpinnings of the rules is helpful to the extent that they are not arbitrary but are ethically grounded. The last thing I wanted to say was that this is me being an amateur sociologist, so I'm way out on a limb here, but American regulation comes out of American culture, which is very laissez-faire, individual entrepreneur. The quantity of very low compliance solo practitioners in the financial services space, they're all over the place. You know, you focus on JP Morgan or Morgan Stanley or Goldman because they're the household names, but I have no reason to believe that the big firms are less compliant than the others are. But that's the way we are. That's the way the United States is. And so you have, what is it? Fake it before you make it in Silicon Valley. That is the sort of the American way. England was different. England, there was, you know, it's been broken up a little bit since the 70s, but there was more of a sense that we were all in it together in England. There were problems with that because it led to the old boy network. But at least the old boy network, and I'm using boys, definitely, that's what it was, had certain standards that they would be willing to uphold. When things were opened up by the London Big Bang, I forget what date that was, in the 1970s, and all of a sudden, it wasn't just the Rothschilds and the Barclays who could open banks, but basically a lot of people could do it. It became a lot more difficult to regulate. I don't know if there's a solution to that problem. It's just something, as an amateur sociologist, I think is there.
Yeah, I think that's right. I think that scaling regulation is a difficult project. I think the thing that Josephine brought up, and it connects to what Robert brought up, that I'm hearing is that compliance professionals don't just have to kind of make sure that people actually do the thing that they're supposed to do, but that there's an educative function to it. And that you know, I don't know that we necessarily, when we talk to compliance professionals, are especially you know, clear about that you know, part of the way you're going to get the 80% to comply is not just through the fact of deterrence, but that they understand how and why they should be deterred. And the why they should be deterred isn't just because of the hammer of the law, but because it's probably consistent with their internal ethical compass. And that sort of goes to the tone at the top question, right? Like, at the end of the day, organizations are only constituted of and by human beings and things. And so, you know, I'm sort of with Brandon Garrett, like, you know, I'm not sure that many individuals are getting, I think there's a perception, right or wrong, that individuals very frequently are not being held accountable for organizational misconduct. And so one of the interesting things that the ALI has sort of included in their tentative draft is a section 6.02 that talks about the kind of the role and conduct of prosecutors and enforcement. And what they say is that what they should be doing is the following: they should promote proactive prosecution of the individuals responsible for the misconduct and provide public disclosure of relevant facts about material misconduct and the basis for and contents of a non-trial criminal, civil, or administrative resolution. And there's a lot packed in there, but one thing that's packed in there, it's section 6.02. One thing that's packed in there is the idea that the reality that, you know, individuals make good or bad choices. And those individuals are both the regulated and the regulators and enforcers. And in many cases, I don't think it's all that rare, for whatever reasons, many reasons, the prosecutors don't prosecute. They don't take the individuals to trial. They don't disclose the facts that were relevant to the decision to try or not. And so there are these sort of procedural failures on the enforcement side that I think ultimately contribute to the cynicism that you know, worries everybody. And you know, it's not entirely clear to me what one does about that. I mean, that was, I think, going back to Robert's question to me, like, what do you do about regulatory capture? And you know, obviously you can try to limit the revolving door and all that kind of stuff. And I think, you know, maybe we should have people post Lon Fuller's, you know, eight, you know, sort of points of kind of lucidity on their walls, because of course that's right. We want, you know, the rules that people make to be clear and to make sense and to be intuitive and so on and so forth. but there are many countervailing forces that obviously make that easier to say than it is to do. So it's not an answer to your, not directly answer to your question, Robert, but I think it's an important thing to bear in mind that what we can do in sort of this moment is help those who are trying to train the compliance professionals, that not only do they have to sort of know the rules and know the hammer for failing to observe the rules, but that they need to and can provide moments of kind of ethical clarity by kind of making a connection between the motivation for the rules and the rules themselves.
This is one of the things that I think Robert wanted to talk about in getting stakeholder buy-in. So let me open the floor to him and let him bring up that topic.
Sure. So I think this is something that's relevant to all of us. Compliance, being relatively new. Compliance is a relatively new field and profession. Law has been around, for a very long time. And I'm a lawyer teaching in a business school. I'm next to business faculty. I teach business students. And so I get their feedback constantly. And I sometimes have a heck of a time in convincing my stakeholders, my students and my colleagues, that legal knowledge is a fundamental tenet that every business person needs to know. How a contract works, how administrative agencies work, how prosecution begins or ends. And I think compliance is another venue toward that. But this is really as much as a question for all of us as it is, because what happens is if students go to an MBA program, and some MBA programs they do, they graduate without a single course in business law or ethics. They graduate and go to one of the highest levels of global firms, but with the legal knowledge no more effective than the average American eighth grader, right? Especially if they come from outside the United States, they don't know even the slightest bit about how laws work. And that's bringing someone who could be a potential ticking time bomb for your organization. And I am curious to hear your responses on how do we proselytize, how do we persuade our various stakeholders, both inside and outside academia, that legal knowledge, compliance knowledge is worth having and worth educating within our given time and monetary resources.
So I've got a quick thought on that. We've been interviewing candidates for a new executive director for our center. And I've had interesting conversations with all of them about that sort of question. And in particular, the sort of work that I think cost benefit analysis can and cannot do. Because I think that, and Rob can sort of check me on this, but my sense is that whether you come out of business school with a robust ethical education and a strong ethical compass or not, you will go into a working environment that does have its own culture. It does have a tone set by the top or whomever. And I think, I don't think the position is we have to comply with each and every rule. And in fact, we do comply with each and every rule, that there is a cost benefit analysis that's involved in, all of those decisions, and the costs and the benefits are, things, not just like sales lost because we had to comply, or revenue reduced because we had to comply, or expenses increased because we had to comply. But, also much more diffuse costs that may be harder to quantify, but nevertheless matter. Things like reputational costs that I think matter, or, and this is, I think, what directly connects to what you're thinking about, sort of what I think of as motivational costs or benefits. So, one of the folks I talked to said, well, I actually think that many compliance professionals, many CEOs and CFOs view compliance as a cost. It's just a cost and it's a problem, and I hate it, and whatever, we got to do it. And he said he views his mission in life as educating them out of that view, that in fact, obviously there are costs associated with it, but the costs associated with like buying the materials you need to make whatever you're selling. There are also benefits to compliance, and one of them that I think is kind of built into what some of us have been talking about is you have kind of people coming on board who I think do want to believe that they're working in an environment that in fact is not aggressively evil, and in fact is trying to do the ethically right thing more often than not, and is in fact consistent with their own ethical intuitions. And so if you want to attract and retain those people, you need to have signaled in an authentic way that that's in fact what your commitment is. It's hardly foolproof, but it is, I think, an important part of the cost benefit analysis that I think sometimes gets lost. It's easier to count the costs the benefits. And then you have the sort of reality that some things are not quantifiable in that way at all, even though I think that that's what, many people come out of MBA school with, a belief in that we can, kind of quantify almost all things. But, like as one of our candidates said, like, I do a talk on FCPA, for CEOs, and I just show them slides of people who've gone to jail recently. And like, that definitely changes their view of life, because like, you can't put a dollar value on that individual cost. I mean, obviously some economists say you could, but like, really you can't. And so I think understanding both the benefit side of the CBA that, kind of we all do either, explicitly or implicitly when we think about these choices, and what can't be quantified, but nevertheless, certainly matters, I think ends up being part of how you can make, you can get the rubber to meet the road in the ways that you might have in mind, Rob. I don't know, Rob, what do you think?
Yeah, I wanted to ask Rob also about nudges, because I am wondering whether nudges also have to work with this underlying framework. You have to nudge people in small behaviors, but it also has to be compatible with what they might be inclined to do already, right? They might. Sometimes it's articulating why this is the ethical thing to do that gets somebody there. So in your example from the nudge unit of just going to talk to the part of the organization that was filling out the forms the wrong way, when there are all kinds of ways of doing the nudge, but you said that the most effective way was just to explain how what they were doing fit into the system. Could we take that insight and then grow that larger into all kinds of other behavioral modifications?
There's a lot of things on the table. I'll start with yours, Josephine. Then Jonathan, if you want me to respond to you, I will. I don't know that that is a universally good or effective technique. It worked there because I understood from our interviews with the offenders, it was clear they thought they were doing the right thing by the firm. They thought this was making the firm's accounting easier in some way by not reporting it 100% accurately, but by sort of combining two trades into one, that kind of thing, which doesn't work when you go out into them, because they didn't realize that their ethical compasses were already engaged. They just had the wrong factual basis for them. And that's an easy one. Other nudges we did were much more difficult. Like we did one where what we were trying to do was to develop a website, because sometimes simply the user interface that people had was so difficult, it discouraged them from doing things in the right way. Just reality. You're dealing with people. They get lazy. They get sloppy. That wasn't a question of no education would have helped them on that. We needed to give them a better mechanism so that when they were at the end of the day and they were just exasperated, they could do it better. So you have to use all the tools in the toolbox. I will say one other thing for the nudge program, which relates to what Jonathan's point was. Goldman had been, I don't know what your view is of Goldman as a compliance department, but I can tell you from the inside, whatever we said went. I mean, that's the reason I stayed there. Yeah, we didn't catch everybody, but during my experience there, from Hank Paulson to Lloyd Blankfein to David Solomon, if we saw that somebody needed to be fired, they were fired. If we said whatever we said went. Nudges were much harder to sell, because because I didn't have to do them, and no regulator. We were out ahead of the regulators on this, and so one of the small dangers, which is not a big issue, but it was something that if you got out ahead of the regulators to something that was more innovative than they were used to seeing, there were a lot of danger signals. They wanted to see everybody doing something similar so that their auditors could come in and see the same thing. And if it cost more, oh my God, let's wait to see the regulators force it into us. So we could only do we had to piggyback on other tech developments. Training was cheap, but we could do that for nothing. That's really what I wanted to say about that, nudges, Josephine. And on Jonathan's point, all of the things that you guys, that the legal world and the prosecutors have put into what makes for a good compliance program, in my experience, work. They're all bits and pieces, and they are all necessary, whether it's tone from the top, training, policies and procedures. We can argue about the effectiveness of individuals, pieces of it, but it actually all works. And I've seen something get missed at one level and caught because of another part of that, another one of the techniques we used. So I don't mean to in any way suggest that those are so I guess what I want to say is what we're doing is, in a rough sense, I think, the right thing to do. I could not think of anything else other than what we're already doing. I will say, however, that I will second your point, Jonathan, and the point of the ALI, that you have to go after individuals, individual actual wrongdoers. I was on the other side. I was a prosecutor, and we didn't even care about the individuals. We just cared about the companies because nobody knew the names of the individuals. I mean, I'll be very blunt about it. You can get, your choice is you can go after an individual who's going to hire a lawyer, who's going to pay, who is going to fight it to the end, or she's going to fight it to the end because they may have to go to jail and it's their reputation, and they're going to get barred from the industry. You're going to get no money out of them because they're not that rich, and nobody in the newspaper is going to care. Or you can go against a headline name. You're going to get hundreds of millions of dollars, and they're going to settle because it's just a cost of business. You have to be extremely ethically pure thinking about the broadest possible scope of how you can best get deterrence, to say, I'm not going to go against the company right now. I think this is an individual. I'm going to spend all my resources on him. And I have not seen a prosecutor's office that has done that. In fact, it's just the opposite. For 27 years, that's what I saw. One time, I will tell you that the prosecutors at the Southern District put one of our people in jail. And for the next year, I could get compliance out of anybody just by showing up. They were scared to death because everybody knew about it. But all those billions of dollars of fines, I actually don't think that they had the deterrent effect on the individuals. The company would put in different processes because they didn't want to spend the time, they didn't want to spend the money, but it worked at the company level, not the individual level. So I second what you said completely.
Right, and I mean, there is this kind of basic, almost, phenomenological question, which is like, does deterrence work as to fictitious persons? And at some intuitive level, the answer has to be no, it doesn't really. Like the entity can always buy its way out because you cannot put the entity in jail. But I think what you just said about the challenges of prosecuting individuals have to be true, and I think made only more true by virtue of the sort of migration from prosecution to the white collar defense bar industrial complex, which I think is very robust and very effective. And I don't know what you do about that. I mean, that to me is I mean, again, it's not my field. It's people like Brandon Garrett, but like I think that's a real issue. It's a policy issue, both for politicians, but also, also for lawyers and those who regulate them and who educate them and help them make decisions about like, okay, do I want to try to spend a few years prosecuting? What does it mean to do that? And what sort of pressures am I going to have to settle? And am I a revenue generator for the government, or am I trying to vindicate some deeper sense of moral wrong? I mean, you can imagine.
Let me interject here for just a second. If anybody's watching this video and doesn't catch your reference, I didn't want to move on beyond it. So when you're talking about this relationship between, I think you called it a prosecutor industrial a white collar crime process, whatever. We're referring to this revolving door that has been well documented between prosecutors' offices and then the people in those prosecutors' offices going into white collar defense firms and making a lot of money on the other side of the table. This is the discussion of that has been in the literature, and if people didn't necessarily have background for that reference, I wanted to make sure that they understood that. Okay, keep
right.
going.
And I just want to say that I don't know that it's necessarily a revolving door. I just think that, over the past 25 years or so, white collar defense practice has become a very robust practice. And I think that that's drained off a lot of resources. So, I mean, I was on a panel with somebody from the Southern District who was like, yeah, we lost, like the median age of our prosecutors went from like, 50 or something to like 35 at some point. And so you just had nobody in the group who'd actually ever tried a case. So like, if you don't have anybody who can say, this is how you try the case, and nobody else has tried a case, like maybe you're going to think twice before trying a case. So it's, I mean, these are all individual choices that people make about what they're going to do with their lives, and they're difficult choices. They're not easy choices.
All right. Wow, we have covered so much ground. I was worried we wouldn't have enough to talk about. How dare I? But we have two other buckets actually left of topics that we haven't even started. So let me ask you guys about these, and maybe I'll throw them out there and see who wants to talk about what. We had put into sort of a next bucket, what are the emerging problems, changes, and or flags that we should be thinking about in compliance? Jonathan, you wanted to talk about when and how compliance fails. Rob had ideas on rules versus ethical conduct. I don't know whether that's been sufficiently fleshed out or not. And Robert had ideas on compliance culture and driving culture. So there's a whole, and then we have a bucket beyond that of surprises and things that we wanted to add. So let's see how this goes. We may go to full time because just so much to talk about, and the exchange has been really good. Let's see, who wants to pick up on emerging problems and changes and flags for compliance?
I can start. Just
Go ahead, Robert. Yeah.
There's a few flags that I think are going to come up. There's ones in the sort of the practical real world, and the others that are more in academia. But I think what's going to happen is there's going to be a rise in measurement. How do we measure successful compliance? What is a compliant firm, and how do we know what it is? In addition, I think we're going to see the rise of analytics and empirical and other quantitative methods in order to measure the effectiveness of the compliance function, and in order to provide the compliance function in an organization. We can see technology monitoring people's trades. Say there's a foreign exchange, entity that has people making trades. The computer will watch and flag problems. So we're going to see the integration of analytics and technology, and also measurement of compliance. That's positive in that computers can do things that humans can't, but there's also a negative. If we rely too much on the technology, too much on the analytics, we may miss compliance that isn't strictly quantitative, non-compliance isn't strictly quantitatively measured. So that's going to be the problem. It's going to be measurement, and through the integration of analytics data and the technology making compliance work. And I think because so much of compliance has come from the legal realm, and it's lawyers talking about compliance, and lawyers are inherently trained as humanists, right? We argue about cases in theory, and our ideas are more akin to philosophers and historians than they are to statisticians. But as compliance becomes more mature, as we saw in the conference, you're going to see more discussion of analytics and empirical methods. And lawyers need to know how those work, and companies are going to have to grapple with using them so that they are effective for compliance, but not rely on them so heavily that they become blind tools that only check the boxes, because it's going to leave you problems later.
Can I just follow up on something that Robert said?
Yeah, please.
Because I was doing surveillance and data analytics for the last 10 or 15 years at Goldman. And I just want to add one other piece. I agree with what you said. We measure what's easy to measure. And that's a problem. What you have the data for, you can measure. And what regulators are looking for us to measure, because they often tell us what they want to measure. This goes back to the point I mentioned earlier, that when they come in, they know what the other 6 people their other regulated have done, and they want to know why you're not doing that. They're not thinking about something new and exciting. They just want everything to look the same. That way they have their own institutional incentives. Nobody can complain because, well, everybody was doing it. I didn't see anything that was anomalous. So those are problems, because there are a small number of things that are being measured, but the behaviors of bad acts are typically pretty rare. And by the time we see them, it's too late. The violation's already occurred. What we really need are effective tools of prediction. Legal and rule violations can often be predicted by other behaviors of the unethical type or of just neutral type. And we don't have good systems on that. And as a consumer of analytic systems, people attempted to sell me vaporware for 15 years saying that they were going to do this, but their choices as to what the key data elements were that were predictive was not analytically rigorous. It was no more than I, in my experience, would have suggested. And the only person I've ever seen do this is Josephine's new colleague, Eugene Saltis from Harvard Business School, who talked to us about some analysis they had done, where they had actually done a regression analysis on a whole massive data sets from HCM of a whole bunch of companies. And they had actually developed real predictive things. I mean, just the kinds of things I'm thinking about were people who had complaints lodged against them, which turned out not to be true. Amazing. They also were the ones who ended up doing bad things at a much higher percentage. People who were on the edge of a promotion, all of a sudden, they were willing to do things that they otherwise wouldn't have, that others wouldn't have done. That's the kind of stuff that I think would be really helpful over time, that people need to actually do the analysis and give us validated warning signs.
Let me ask you about something else. Is coming to Robert's point and Rob's point, when you atomize things into, individual pieces of data, you also miss the big picture. And certainly we have seen this with regulators where, they have in the financial crisis, oh, wow, we're having a lot of mortgage fraud complaints. They missed, the huge issues of, what was happening across the market because they were so focused on this. Or even in the Wells Fargo example, when 5,300 employees are fired for exactly the same behavior, it was divvied up into different parts of the report for the board. So they never aggregated 5,300 employees engaging the same behavior. They were all fired for slightly different things, right? So you could kind of sweep it under the rug because, yes, we reported the data, but, we atomized everything so that you couldn't get the full picture, and nobody saw, this huge line of 5,300 employees fired for the same behavior and started to ask what was that behavior and what was going on and what were the more systemic risks to the company and the company's reputation. And so I'm worried that compliance, by going to this micro look, is missing a lot of things, and that's that. So Rob's concern really resonates with me when he says, hey, how do I watch for patterns? How do I watch for the big things? How do I know who to spend my time, energy, and resources on, and how do I prioritize amongst all these things? And I wanted to ask you guys for your ideas on this. How do we, obviously data analytics is here, people analytics is here, these programs are going to be used, the surveillance is going to be used, the data is going to be collected. How do we help ourselves from falling into that trap of just being so myopic in how we're thinking about what we're measuring? And there's that old expression, which is actually, I used to work at the Drucker School, right? Peter Drucker's school. Peter Drucker is constantly misquoted as saying, you can't manage what you can't measure. And that's not what he said. He said you need to manage all kinds of things. You need to manage people, you need to manage processes, and you need to manage culture. You need to manage all these things. And some of it you can measure and some of it you can't. And some of it you won't see until it's gone. Employee morale, ethical behavior, team cohesion, lots and lots and lots of things we can't measure, we don't see and don't come to the radar until they're big. So talk to us about this issue, because I think Robert's right. This is coming, and what Rob's talking about, people pushing this software and the regulators pushing these formats, I think it's got a real downside.
Yeah, I think it does. Oh, Rob, did you want to go ahead first?
I'm happy to. I think I'm going to give you very practical suggestions. People need to be, to run analysis, you need formatted data. You need something, or you need a system that will do something, a computer system. And so people have to be very creative about what they're doing. And there has to be somebody at the other end who analyzes it. So I'm not going to give up on data. I think we need to come up with new ways of doing data. And based on my own experience, where Goldman has more programmers than Facebook does. I mean, it's a massive data-rich firm. And even we were able to, it's really hard to create a new database saying we're now going to capture new things. And sometimes it requires you to actually go out and develop new data. It's nowhere in a database. Like Josephine was talking about culture. I mean, you might have to do a survey. You might have to actually question employees and then find out that there are parts of the company that are feeling very alienated, which you otherwise wouldn't have known, but you can just do it in comparison with a survey. And by the way, there's the British Banking Association. There was that group in London who did that. So that's one. Two is now for the big picture things, like what's the next big blow up? The weird thing is we all know what the next big blow ups are because you can read them in the paper every day. And the problem is that there are, out of 100 things which are going to destroy the world, only one of them may actually happen, or none of them may happen. So it's not like, people were not thinking about during the financial crisis of 2008, 2009, that there is this moral hazard. It was talked about, but everyone from Alan Greenspan to the Fed officials to most everyone in the industry didn't think it was as real as it was. Everybody's a genius in hindsight. So, right now I could list for you 20 things that I've read in my literature over the last 6 months are going to destroy the world. The United States economy is going to crash. We're going to have all these problems, whether it's COVID or all the trillions of dollars, and all it takes is, and one thing happens, then that one person who predicted that is going to be a genius for a period of time. I think there's a certain amount of uncertainty that's necessary. The last thing I'll say, because I know we're running out of time, I believe, Jonathan, that needs to get going, is reverse stress tests. Are you familiar with reverse stress tests? They're really fun. You don't say, okay, I want you to stress what would happen if this, and this happened. You do it the other way. You say, you're out of business. What could have put you out of business? So you start out, and it's interesting what people come up with. And there were formalized reverse stress tests that we used to do occasionally, which were fascinating. Because then people's real fears sometimes come out.
You could almost call it like bankruptcy backwards, right? Like imagine you're in chapter 11, how did you get here? Yeah. I do have to jump. And so I just wanted to quickly say, obviously there's a great deal more that we could all talk about, including, with respect to data and algo and tech and sort of the human motivations. I certainly think that tech is going to matter. I certainly think that humans matter more. And because the humans create the tech and the humans misuse the tech and the humans have to, the lawyer humans have to figure out how to be not fooled by that. But, I think this has been a great panel. I'm grateful to you, Josephine, for pulling it together. And Rob and Robert, thank you so much for your observations. I'm sorry, Cynthia couldn't join us. But, if you guys would like to be in touch about any of this stuff or about the ALI project, please be in touch with me. I think you all have my contact information. Obviously, feel free to continue to talk, but I just got a text from my daughter saying, I'm going to be at the airport early. So I am not going to be late. And so I need to jump. But
thank you.
Good
thank you again.
Thank you, guys.
Thanks.
That's amazing.
Well, good. I guess we can probably, it's up to you. We can close it out. I think we've hit our normal.
Yeah. Well, Rob wanted to talk about your work with IPOs, and I have a note that to bring that up if it didn't come up earlier. Oh, you're muted.
This is a whole separate issue. We have
a couple of minutes, but yeah, go ahead.
Okay. Earlier I talked about the non-legally required ethical principles and how they play into a compliance program. What I didn't say is that in my experience, by and large, these principles in the United States are relatively uncontroversial, whether people are religious or they're atheists or utilitarians or Kantians. They all know lying to clients is bad, falsifying business records is bad, sexual harassment is bad. They may not do what the right thing is, but they know what's right. And I never really had too much trouble when people would come to me with those kinds of questions. We would be in figuring out what principles should motivate them or how they should be motivated. The details sometimes were difficult. However, over the last 10 years, a whole bunch of new things companies are being asked to put into their ethics bucket. I would call them normative responsibilities, because I'm not sure technically they're ethics, they're more normative responsibilities, things we should do. Companies are being asked to accept responsibility for social and political consequences of their actions. Those are much more controversial. I'm talking about everything from ESG to cancel culture. I had to referee a number of these judgments at Goldman, and I can tell you they're much more complicated, and there's nowhere near the kind of universal consensus that exists on principles like don't steal or don't lie. So just to give you a little background for the audience, Milton Friedman has this doctrine that company has a sole responsibility with shareholders. That was very prominent in America over the last 50 years, but there has been a big reaction over the last 10, 15 years, probably I think starting from 2008, 2009 crash. And we now have the response is really stakeholder now, and stakeholders are important, not just shareholders. And stakeholders can be customers, they can be your employees and the wider society. And there's a battle going on right now in corporate America about which effects of the actions of a corporation should the corporation take responsibility for. And for those that they concluded they should take responsibility for in the wider society, there's still a question about whether the effects of the behavior, the effects that they're producing are good, bad, or neutral. So when I was at Goldman, I was on the capital and commitments committees, and we approved large new financings and IPOs, and we had those discussions all the time. So I'm going to go over a couple of quick cases, very quick. And note, every single one of these cases I'm going to describe, I'm not going to use names, but everything that we were considering doing was legal, 100% legal. So is it okay for us to fund a new coal plant in India, where that may be the only way to deliver reliable power over the next 20 years to an impoverished community? Should we be excoriated for doing that? Or should we be supported? Because that's the only way the residents were going to get power. And if you have no reliable power, people are going to die. Is it okay to fund a road building project in Thailand, sponsored by the government, that is going to impact the habit of an endangered species? I think they were tigers, is my recollection. What's the right answer? Is it okay for us to IPO a company that makes e-cigarettes, which will save the lives of existing smokers who switch from regular smoke to e-cigarettes, but may hook new young smokers on nicotine? Is it okay to refinance a gun manufacturer or a cable network that provides pornography to its customers? Or is it even okay to tell a company that will only IPO them if they have a certain number of women on their board or minorities? I want to raise a number of issues about this. Number one, to put it mildly, companies have little expertise on these questions. And at least in my experience, their response is often more motivated more by political pressure or executives' social networks than by any careful analysis and deep ethical beliefs. But when they do take a public view on these, companies have to know that they may be creating ethical obligations or legal obligations for their employees and for purchasers of shares of the company, and they have to fulfill those obligations. And their descriptions here are often far more contested than the don't cheat or don't steal type of obligations. And that can result in one way or the other, boycotts, declines in revenue. You do this, you're going to get boycotted. You don't do it, you're going to get boycotted. And if it's not, if the principle that you're deciding that you want us to take into account in your company is one that is not accepted universally by your employees, you can end up with a lack of productivity in the workspace. You can end up with disputes, a breakdown in culture. Jonathan Haidt, back in 2018, argued in a talk I saw that he would not recommend companies to encourage employees to bring their whole selves to the office, because if they do, they're going to get into fights. And now you finally have, this is the last thing I'll say, the group that is probably most representative of the sort of the new stakeholder capitalism is the Business Roundtable, which is all the major companies. In 2019, they stated that they basically said that we have a social responsibility and we're going to act on it. And now we're seeing the beginning of a backlash. mostly from Silicon Valley. It's something called the Mission Protocol, Shopify and Coinbase, which is taking a position somewhere between full stakeholder capitalism and Milton Friedman. And I'll just read you two quick things from their mission statement. Working in a single direction on a strong, well-considered mission is the best way to make a socially positive impact. That sounds like Milton Friedman. We just do our job. We have that's our social impact. But then it says, missions can and should take a firm political stance, but only when furthering the specific goals of the project and not those outside its stated scope, which I take it means if you're an environmental if you're an energy producer, you have to care about global warming. If you're Shopify or your Coinbase, global warming should not be your concern. Focus on what your mission is. I think this is going to be a fascinating area of development, and I think it falls within the compliance framework, but it's going to be much more contentious than even the difficult things we've had before. That's what I wanted to say, Josephine. Thoughts, comments, responses?
Fascinating. And I think what's most interesting is this pushback from this mission protocol is that it comes from tech companies. Tech companies tend to be market makers more than markets. They bring people together. So if I'm an ISP or if I'm Facebook, I'm bringing product and market. I can very easily say that almost anything is outside my concern because I'm just the joiner. I'm not the actual maker, buyer, seller. I'm the middleman. And so the mission protocol sounds perfect to technology companies who don't have that traditional manufacturing retail focus, who can walk away and say, well, this is just not my problem. So that was really interesting insight. And I guess the last thing I'll think of is that overarching theme for a discussion like this and what compliance professionals need to do. Have you ever heard the classic joke about the economist and the street light? I don't know if you've heard this before. So it's a joke. Maybe it's only funny for economists, but here it is. So police officer was walking down the street late one night, and he sees an economist, and he's standing under a street light, and he's looking around on the ground. And the police officer comes over to the economist and says, "Is there something wrong? What happened?" And the economist says, "Oh, I feel really bad. I've been looking forever. I lost my keys and I can't find them to my car. And if I can't find my keys, I can't get home." And the police officer says, "Well, you lost your keys. That's too bad. Where do you think you lost them?" And the economist goes, "Well, I lost them way over there." He points 100 feet away to a dark corner. And the police officer says, "Well, if you lost your keys way over there, why aren't you looking for your keys there?" And the economist says, "Well, this is where the light is." And that's, I think, a key theme. If you think about it, about understanding compliance and understanding the importance of rules and regulations, we need to not simply look where the light is, where it is convenient, where our standard models and concepts drive us to be, and where our own analytical frameworks point us. We look at places that challenge what we think and question the very lessons that we've learned in our education, so that we no longer just search in the light when the solution is somewhere that may be a little more difficult, but it is the actual and true one.
I think I'll give you guys the last word. That was wonderful. Both of you. Wow. All right. Well, hopefully this recording is helpful to posterity, and that it'll be up on ComplianceNet and people will enjoy it and really benefit from what you guys have talked about. This has been rich, deep, incredible discussion. So thank you. Thank you again for making time for this and for coming to talk.
Thank you, Josephine. Thank you, Robert. It was fun.
Thank you. Pleasure working with you.
All right. Take care. Bye.